Hello, we have an emergency here. Please get the on-call ENT surgeon and the anesthetic down here immediately. There's actually an emergency. Please hurry up.
What do we do now?
Welcome the medicine.
ENT surgeon, please move away. Miss, can you tell me the condition of your husband?
My husband cannot stop choking. He just had surgery 2 weeks ago and now we're gonna stop bleeding. And his surgical wound is still open. Please help me.
The surgical wound from his previous operation have ruptured. The hemorrhage is too heavy to control here. Miss, you need to move him. The operation theater now. Nurse, move him now.
Please, Dr. Becky, do whatever you can to save my husband.
We do our best.
Madam, I need you to review this consent form for your husband's emergency surgery and place your signature at the bottom. We need to move him right now.
Please for my husband to see.
God, there is too much blood. This section is not working. I cannot see his airway to put the tube in.
Hurry, Dr. Shahida. His oxygen is dropping, you know.
Stop pressuring me. I cannot see anything. His heart rate is crashing and he is literally going into cardiac arrest.
Move up. Let me help you. Press it down on the bleeding wound. The airway is clear now. Put the tube in.
The tube is in. He's getting the oxygen.
His bleeding stopped, but he went too long without oxygen. His brain getting damaged.
He's alive, but he's not waking up. The lack of oxygen caused severe damage to his brain.
Please, Michael. Please. Please, Michael. Please. Miss Alia, I don't know where else to go anymore. For months, I've been writing letters to the hospital, begging them to explain what happened to my husband. But every reply sounds the same. Columbia Asia merely provided the facilities. Doctors were independent consultants, and the hospital bears the responsibility. How can they say that after what happened to my husband?
I'm sorry to hear that, madam. That is because the hospital strategy. That's how many private healthcare providers protect themselves from liability. They create layers of legal separation. The doctors become independent consultants. The hospital claims it only supplies the room, the machines, the nurses. So when something goes wrong, they try to disappear from responsibility.
But we trusted the hospital. We never chose the anesthetists ourselves. Everything was arranged by them. The appointments, the surgery, the payments, everything carried the hospital's name.
Exactly. Look here, madam. This is the admission form signed with the hospital logo and billing statement issued by the hospital. The consent forms processed through the hospital administration. You didn't enter into a contract with the doctor personally. You entered into a contract with the hospital itself. That changes everything. Madam, you can have a look on this document. Realize with the significance of the document.
So, the hospital cannot wash their hands like that? Is that what you mean?
Not if we prove they owed a non-eligible duty of care. And under the Private Healthcare Facilities and Services Act 1998, hospitals in Malaysia have statutory obligations. They cannot simply profit from patients while avoiding responsibility when negligence happens inside their own operating theatres. Do you realise that, madam? This case is bigger than medical negligence. This is about accountability, because if hospitals can escape liability by hiding behind this paperwork, then every patient in this country is vulnerable.
Miss Alia, do we even stand a chance? They are powerful. They have money, lawyers, influence. I can barely afford my treatment anymore.
Mr. SIOW, the law was never meant only for the powerful. And sometimes, one case changes everything. Wait, I need to have a look on the federal authorities. We are not only suing the anesthetists, we are bringing the hospital into this fight directly. We will argue vicarious liability, we will argue non-eligible duty, and we also will challenge the entire consultant arrangement structure. And if the High Court refuses to listen, we appeal. If the Court of Appeal refuses, we take it to the Federal Court.
Miss Alia, you really believe we can win?
Okay. So as I look at the medical file, I believe the truth is on your side, and truth becomes dangerous when someone is finally brave enough to fight for it.
Honey, I'll try my best to make sure you get the justice you deserve.
What happened in that operating room changed your life forever. Now it's time someone answers for it. This is the notice of suit against Columbia Asia and others. We begin today.
We are now going to deliver the final decision in civil suits number BA23 NCVC 10/2017 between SIOW CHING against Columbia ASEAN Sdn Berhad and others.
Madam Chow Wai Kin, please state your full name, age and current occupation for our record.
My name is Chow Wai Kin. I am 51 years old and I am currently a free-time caregiver to my husband, SIOW CHING.
What is your relationship with plaintiff Mr. SIOW CHING, and in what capacity are you appearing in court today?
He is my husband. I am appearing today both as his wife and as his legally appointed litigation representative because he is completely unable to speak or act for himself.
Prior to the tragic events of March 2010, could you describe your husband's general health, occupation and role in your family?
He was 35 years old and in excellent health. He was an active, hardworking man and director in our two family-owned companies. He was a breadwinner, a loving husband and an absolute leader of our family. Thank you.
Madam Chow, could you describe your husband's medical condition when you arrived at the defendant's hospital at 3:30 a.m. on March 22, 2010?
My husband, SIOW CHING, had surgery on his throat and sinuses about 12 days earlier at another hospital. He seemed to be recovering well, but early in the morning of March 22nd, he started bleeding heavily from his throat at home. The bleeding was very bad and we were very frightened. We quickly took him to the nearest hospital, which was the third defendant's hospital. He arrived at about 3:30 a.m. When we got there, my husband was in a very terrible condition. Blood was pouring from his throat. He was choking on the blood, spitting it out, struggling to breathe and becoming weaker because he was losing so much blood. Then the EMT surgeon, the first defendant, examined him and said he needed emergency surgery right away to stop the bleeding. My husband agreed because he trusted the doctors to help him. He was then taken to the operating theatre with the surgeon and the anesthetist. I believed he would be safe, but things became worse. Just outside the operating theatre, his bleeding became much heavier than he started vomiting. The doctors had difficulty putting a breathing tube into his airway. Because of this, his oxygen and blood level dropped very, very low. Although the doctors later managed to restart and stabilize him and completed the surgery, his brain had already been damaged from not getting enough oxygen. And as a result, my husband suffered severe brain damage. Before going to the hospital, he could walk, talk and take care of himself. But now, he is permanently disabled, both mentally and physically, and can no longer look after himself. And that is why I am here today, acting on his behalf, seeking justice for what happened to him.
Is it enough as for now?
Yes.
Thank you, Madam Chow Wai Kin, for the explanation. My lord, I tender the witness for cross-examination.
Dr. Sharida, what is the exact nature of the relationship between hospital administration and the consultant specialist working at this facility?
Actually, they operate as independent consultants under a resident and consultant agreement. They maintain absolute clinical independence over their patients. The hospital has zero oversight regarding their minute-to-minute clinical judgments.
How does the hospital ensure the quality of care and safety of its clinical infrastructure?
We strictly comply with Act 586. We provide fully maintained, state-of-the-art operating theatres, emergency equipment, fully credentials and qualified nursing personnel, and high-volume suction devices. As I know that all equipment was functioning flawlessly on the night of the incident.
Please walk His Lordship through the exact administrative process that occurred when the plaintiff arrived at the emergency room at 3:30 a.m. and clarify how the hospital coordinates its specialist roster during such an emergency.
Okay, as what I remember, when the plaintiff arrived at our facilities expressing a severe post-tonsillectomy hemorrhage, the hospital's internal emergency intake system functioned exactly as it was really and operationally designed to do. On our duty, emergency medical officer immediately conduct an initial triage, stabilize the patient as far as clinically possible within an A&T setting, and instantly activate our specialized on-call roster within a minute. The hospital successfully contact and mobilized on our on-duty consultant specialist, which is Dr. Mugat Shiraz, the ENT surgeon, and then we also called for Dr. Nur Shahida, the consultant anesthetist, and both of our doctors arrived promptly at the hospital premises and took total active clinical control operations. The hospital administrative or BHD is to provide a seamless, rapid bridge between an incoming emergency and the specialized medical minds required to treat it. Once those consultants assume control, the administrative intake phase is successfully complete and the patient is officially under specialized clinical management.
Thank you, Doctor. My lord, I tender the witness for cross-examination.
Doctor, when Mr. SIOW arrived at your emergency room at 3:30 a.m., choking on his own blood, he walked in with a private doctor, is it?
No,
He did not choose Dr. Nur Shahida either, the negligent anesthetist, did he?
no, she was the consultant on our emergency roster for that day.
Exactly. Your hospital's internal system selected her, and your staff summoned her to treat this bleeding patient, correct?
Yes, that is how our emergency specialist roster operates.
Now, let's look at what happened on your premise. Is it true that catastrophic collapse happened in the airlock area outside your operating theatre?
Yes, that is where the patient gets rotated.
While in that airlock area, the patient was actively vomiting copious amounts of blood and suffocating, correct?
Yes.
And your chosen delegate, the second defendant, completely failed to execute the alternative emergency life-saving airway procedures. While he was actively in blood, is it correct?
Yes, clinical findings shows she failed to secure the airways in time.
Let me put it to you directly, doctor. A private internal contract between your hospital and a doctor cannot strip away your statutory duty to keep an emergency patient safe under Malaysian law, correct?
Contract governs our staff, but we must operate under the law.
And under the law, your hospital delegated its core life-saving duty to an incompetent doctor who let a patient suffocate on your operating floor, making Columbia Asia fully liable for this tragedy, correct?
We disagree. We provide the infrastructure. We did not cause the clinical failure.
Thank you, doctor. No further question, Yang Arif.
Madam Chow, you were fully aware that your husband had his originator colectomy surgery at a completely different hospital, specifically Subang Jaya Medical Center, correct?
Yes, that is correct.
When you arrived at Columbia Asia Hospital, you signed standard admission and registration forms acknowledging the terms of care, did you not?
Yes, I signed them in panic while he was bleeding.
Right, and those forms explicitly stated that the attending consultants are independent practitioners and not employees of the hospital, correct?
I did not read the fine print. I just want my husband safe.
Now, the recommendation to take your husband to the operating theatre to stop the bleeding was made entirely by the ENT specialist, Dr. Magashiras, correct?
Yes.
The hospital's administrative board did not dictate how that surgery should be performed, correct?
Yes.
When your husband collapsed in the airlock area, the split-second decision on how to clear his airway or insert an oxygen tube rested entirely with the anesthetist, Dr. Nur Shahida, correct?
Yes.
You do not expect a hospital business manager to step into an operating theatre and tell a specialist doctor how to perform a medical resuscitation, do you?
No.
So you agree that the medical equipment and rooms provided by the hospital were fine, and that the crisis occurred purely because of the individual clinical choices made by the independent doctors, correct?
Yes.
Thank you, Madam Chow. No further questions, Yang Arif.
May it please the court, Yang Arif, my name is Nuri Alamiti representing as the counsel for the plaintiff, Xiao Qing represented by his wife, Madam Chow YEE. Yang Arif, this is a tragic case of a catastrophic system and clinical failure. The plaintiff walked into the third defendant's accident and emergency department seeking urgent medical intervention for a post-surgical hemorrhage. He was an exceptionally vulnerable patient, completely dependent on the medical system provided by the hospital. Instead of receiving seamless, coordinated life-saving care, he suffered massive cerebral hypoxia inside the airlock area of the operating theatre, leaving him permanently and severely disabled. The defendants attempt to hide behind corporate agreements, claiming that the specialist doctors are dependent contractors. However, we submit that the Private Healthcare Facilities and Services Act 1998 shatters this defence. The statutory framework places a direct personal and non-negligible duty on private hospital to provide safe, comprehensive healthcare services to the public. The patient knocks on the hospital's door expecting medical treatment from the institution itself, not a fragmented assembly of disconnected.
May it please the court, Yang Arif. My name is Zuriati binti Zakaria. I appear on behalf of the third defendant, Columbia Asia Sdn Berhad. Yang Arif, the third defendant is a properly managed, fully equipped private healthcare facility. We submit that the hospital discharged its legal and administrative duties completely. It provided state-of-the-art facilities, operational theatre units, trained nursing staff, and fully certified independent specialist consultants. The resident and consultant agreements produced in this court clearly establish that the first and second defendants are independent medical specialists operating their own practices within the hospital premises under a contract for services. The clinical decisions, including the methods of anesthesia, airway management, and surgical interventions, rested entirely and exclusively within the independent professional purview and specialized expertise of those doctors. The hospital does not and cannot, under law, direct a specialist surgeon or anesthetist on how to perform a clinical procedure. To impose a non-negligible duty of care on a private hospital for the independent, split-second clinical decisions of autonomous specialists would place an unreasonable financial and operational burden on private healthcare providers.
Are now going to deliver the final decision in civil suits number BA 23 NCVC 10/2017 between CHING against Columbia ASEAN SDN and others. From the evidence as a whole, the plaintiff has simply failed to establish any causal link between the first defendant act and or omission and the injuries that he suffered. The catastrophic brain damage sustained by the plaintiff had no connection with any intervention or alleged failure to intervene by the first defendant. The act or omissions complaints of do not amount to negligence that would warrant a finding of apportionment of liability against the first defendant. Accordingly, the claim against the first defendant is hereby dismissed. Regarding the allegation of specific direct clinical negligence against the third defendant hospitals, this court finds that the plaintiff has failed to adduce any credible, let alone sufficient, evidence to prove those distinct particulars against the hospital. Furthermore, on the issue of vicarious liability and direct non-deligible duty, the contractual evidence produced in court, specifically the resident and consultant agreement, demonstrate that the first and second defendant were at all material times practicing not as employee, servant or agent of the hospital, but strictly as independent contractor. The plaintiff on pleading admit that the first and second defendant had themselves up as independent contractor. He cannot now contend that there was a private agreement or arrangement between the doctor and the hospital without the knowledge of the patient. Finding no further basis of direct but breach or spirit deliberation to overturn this status on the current record, the claim against the defendant hospital is dismissed. First, the plaintiff claim against the first defendant is dismissed. Second, the plaintiff claim against the second defendant is allowed with damage to be assessed by register. Third, the plaintiff claim against the third defendant is dismissed. Fourth, costs are awarded to the first and third defendant to be taxed unless agreed. The second defendant is ordered to pay the cost of the plaintiff to be taxed unless agreed. Court is adjourned.
May it please this Honourable Court Yang Arif, I appeal for the appellant, Madam Chow Wai Kin, represent for Mr. SIOW CHING.
Thank you, Counsel. We have read your extensive submissions. The core of this appeal rests heavily on the profound question of medical law. Can a private hospital escape vicarious liability for the negligence of a consultant doctor by simply classifying them as an independent contractor? Counsel for the appellant, you may proceed.
Much obliged, Yang Arif. Our submission is clear. The respondent hospital is vicariously liable for the tortious act of the consultant doctor. The hospital cannot insulate itself from liability through a paper label. We submit that the modern two-stage test for vicarious liability is fully satisfied here. First, the relationship between the hospital and the consultant doctor was one akin to employment. The doctor was fully integrated into the hospital's business operation, and the hospital exercised significant organizational control for her practice. Second, there is an undeniable close connection between that relationship and the tort. The negligence act occurred while the doctor was executing the exact medical service the hospital engaged her to provide to its patients. Therefore, the mere defense that the consultant was an independent contractor must fail. Thank you, Yang Arif.
Thank you, Counsel. We hear you. Now, let us hear from the respondent.
Respect, my ladies, my lords. The courts below were entirely correct in finding the hospital not liable. The consultant anesthetist signed a residential consultant agreement which explicitly designated her as an independent contractor, not an employee or agent of the hospital. The agreement specifically states that the hospital is not responsible for her tortious acts and that she must indemnify the hospital. Furthermore, as a matter of fact, the hospital did not exercise managerial control over her clinical judgment. The hospital is merely a provider of facilities, medical equipment, and nursing staff. The doctor operated as an entirely independent economic entity.
Council, with respect, that rigid focus on the strict contract of service belongs to a bygone era. Look at the legislative framework. Look at the Private Healthcare Facilities and Services Act 1998, Act 586, and its 2006 regulations. It is not the clear legislative intent of Act 586 to present the hospital as a singular, unified provider of healthcare services to the public rather than a mere landlord. While note is taken of the dissent, the majority of this court finds that the two-stage test for vicarious liability is fully satisfied, strongly reinforced by how private healthcare structures operate under Act 586. A hospital cannot defeat vicarious liability simply by pointing to internal contractual arrangements or indemnity clauses. The reality of the integration and the relationship overrides the labels used in the paper contract. Accordingly, by majority, the appeal is allowed. The decisions of the courts below are set aside, and the respondent hospital is held vicarious liable for the full sum of damage. Court will adjourn.